afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have Brian Hogan presenting for us. If you are unfamiliar with the format of this event, first, Brian is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comments section on Facebook. We'll review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum and Legal Aid is not representing you at this time. Brian will go over this in more detail, but please remember to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Brian to get us started.
Thanks, Marissa. So as Marissa mentioned, I'm Brian Hogan. I'm an attorney in the Greensboro office of Legal Aid of North Carolina. And in my role as the firm's practice group manager for public benefits, I help oversee Legal Aid's work in the area of Social Security disability law, which is what we're going to be talking about today. So the topic for today is post-entitlement issues for Social Security disability insurance and supplemental security income beneficiaries. What is a post-entitlement issue? Essentially, this presentation is about the issues that current Social Security disability insurance and SSI recipients may face when receiving benefits from the Social Security Administration, and what to expect and what to do if you face one of these post-entitlement issues. And we're going to be focusing on three separate areas. The types of non-medical issues that can come up when you're an SSDI or SSI beneficiary. We're going to talk a little bit about Social Security overpayments and what you can do to try to remedy or lessen the impact of those overpayments, and also continuing disability reviews. So before we talk more about these post-entitlement issues, I just wanted to take a step back and talk about the differences between Social Security disability insurance and SSI. So hopefully if you're watching this, you are a current beneficiary or you're applying for Social Security disability insurance and SSI. And so this presentation will be helpful in understanding what issues you may see in the future when you are a beneficiary. Social Security disability insurance, sometimes referred to as SSDI, like I've been saying, but also you may hear it referred to as DIB or DIB when you're talking to a Social Security field office worker, or you may see it referred to as a Title II benefit. Title II refers to Title II of the Social Security Act, which is part of the Social Security Act that implements the Social Security Disability Insurance Program. Sometimes you'll hear Social Security workers refer to this as a Title II benefit. As the name suggests, Social Security disability insurance is an insurance program, meaning that you are paying into an insurance system. So you become insured. So if you become disabled or you hit retirement age, you can receive a benefit from that insurance system that you've been paying into during your working life. And if you are receiving a paycheck from an employer, you know that you're paying Social Security taxes. This is the tax that's taken out of your weekly or biweekly or monthly check called the FICA tax. And when you're paying those taxes into the system, what you're receiving in return are work credits, quarters of coverage, so that when you do hit retirement age, or if before retirement age you're unable to work because of a disability, you are insured in that system. And again, you can pull back a benefit from that system that you've been paying into. The amount of the benefit that you will receive, either when you hit full retirement age or become disabled and eligible for Social Security disability insurance, is called your primary insurance amount, your PIA. And this amount is different for everybody. It's based on your wage history, your work history, how long you worked and how much you paid into the system. So SSDI is not a means tested benefit, meaning the amount that you get paid per month is not dependent or contingent on your other sources of income or your resources. It's a fixed amount based on your wage history. But in order to get this benefit, you must be disabled under the Social Security Act, must meet the definition of disability. And again, you must be insured. You must have paid or earned enough quarters of coverage in the system to be insured for this program. And Social Security disability insurance beneficiaries, after 24 months of eligibility for benefits, also will receive Medicare. So I want to compare Social Security disability insurance to SSI. So SSI, Supplemental Security Income, is sometimes referred to Title 16. Title 16 refers to Title 16 of the Social Security Act. That is the part of the Social Security Act that implements this program. This is a means-tested program, meaning that if you have other income or resources, it can impact your eligibility and the amount that you receive under this program. So your benefit amount can be reduced if you have other income, or if other income is deemed to you, say from an ineligible spouse, or if you're a child SSI beneficiary from a parent, or it can be reduced because you are receiving in-kind support from other individuals, meaning that you're receiving essentially shelter from other individuals. Now, the maximum benefit amount that you can receive for SSI is set by federal rules, and that amount right now, the highest amount you could possibly get is $967 per month in 2025. But again, that amount could be lower if you have other income, or if other income is being deemed or attributed to you because of in-kind support. And again, this is a needs-based program. And as a needs-based program, it has certain resource caps or thresholds. So for an SSI beneficiary, if you have more than $2,000 in resources available to you, then you're not eligible for the program. So that's a big difference between SSDI, which does not have a resource cap. It's possible to have resources in excess of $2,000 available to you and be eligible for SSDI, but not eligible for SSI if you have those resources. And to get SSI, again, you have to be disabled, and that definition of disability is actually the same as the SSDI program. Same exact definition of disability. And the other way to get SSI is if you meet the income and resource test and you're 65 years old or older. And individuals that get SSI also get Medicaid health insurance. So these are some basic distinctions between the two programs. But these distinctions are important because it impacts what types of post-entitlement issues you may see as an SSDI and or SSI beneficiary. So what are common reasons that SSI beneficiaries may see their benefits stopped? So the two big ones are going to be because you have excess assets, that's countable assets over $2,000 for an individual, or you have excess income. I mean, there may be other reasons why you may become ineligible for SSI if you're receiving it for non-medical reasons, but these are the two big ones essentially. If you have more resources than is allowable, or if you have more income than is allowable, your SSI can be stopped. For SSDI beneficiaries, the biggest reason we see SSDI stop is people attempt to return to work under Social Security's work incentive programs, something called a trial work period or an extended period of eligibility. But the rules are complicated, and folks a lot of times don't understand these rules because they're so complicated, and they may run afoul of these rules, and then Social Security will stop your benefits because you are working what's called above substantial gainful activity levels outside of your trial work period. Here's something that's important for you to know is that when Social Security is going to stop your benefits for one of these reasons, it has to send you a notice of planned action, a notice saying we're going to take these steps because of a specific reason. And that notice of planned action is going to give you appeal rights, allowing you to contest the action that Social Security is proposing. And so if you believe that Social Security's determination that you are either, say, above the asset threshold or income thresholds for SSI is incorrect, it's really important that you appeal these decisions within the deadline set out on that notice. Generally, you'll have 60 days to appeal in a decision that you receive from Social Security, but there are some exceptions. If you want to keep your benefits, though, pending the appeal, you need to do so with even shorter timelines if you don't want your benefits to be cut off. And for the SSI program, that would be essentially 10 days to file that appeal so that there would be no interruption of your benefits. So these are common reasons why an SSI or SSDI beneficiary may receive a notice of plan action or a notice of revised decision stopping their benefit payments going forward. I mentioned Social Security work incentives. These are Social Security's complex rules that do encourage SSI and SSDI beneficiaries to try to attempt to return to work while getting benefits. A lot of times, though, again, a lot of people get caught up and they run afoul of these rules because they're so complicated. But if you want to know what the basics of these rules are, to try to understand them, and again, they're very, very complicated, Social Security publishes something called the Red Book. It's the guide to work incentives and employment supports for people who have disability under the SSDI and SSI programs. And you can find a copy of the Red Book at ssa.gov/Red Book. And it goes into detail about some of the work incentives that are available to folks who want to test out their ability to return to work after being on SSDI or SSI because of their disabilities. So another big post-entitlement issue that many of our clients face, and a lot of times they're tied up with the cessation of benefits going forward, are overpayments. So it's common for SSI and SSDI beneficiaries to receive in the mail a notice from Social Security called a notice of overpayment, where Social Security is going to tell you, we paid you too much money. We paid you too much in benefits, and it can be for a variety of reasons. And it could be nothing to do with anything that you have done wrong. A lot of times you will not be at fault for the overpayment. It could be due to agency error or other issues. And this notice of overpayment is going to say, you owe us back this set amount of money. And sometimes it could be tens of thousands of dollars. And it'll also tell you that you have appeal rights if you disagree with this notice. And it will also tell you that you have the option to request a waiver of the recovery of that overpayment. We'll talk about that in a moment, about those options available to you. But I want to talk first about some of the common reasons why you may receive an overpayment notice from Social Security. So for the SSI program, similar to the cessation of benefits, a notice of plan action, you might also receive a notice of overpayment for the same reasons, because you have excess assets, assets that are over the resource limits and your benefits were not timely stopped by the agency. You may have excess income, so countable income over the limits that would make you ineligible for SSI, and your benefits were not stopped or reduced in a timely manner. Likewise, you may also have your benefits reduced and be issued an overpayment because of receiving in-kind support. It's also possible that you may have an overpayment because Social Security has determined that you are no longer disabled and you are receiving benefits paid to you during the appeal of that decision. These are called statutory benefit continuation benefits. So those are the common reasons we see here at Legal Aid of North Carolina where folks may receive an overpayment notice for SSI, essentially because you have assets above the asset limit, you have income that should have reduced your benefit or stopped your benefit entirely, you were receiving in-kind support and maintenance, and Social Security did not timely reduce your benefits, or Social Security has determined that you have medically improved and you are no longer disabled, and you were receiving benefits pending those appeals. We'll talk about CDRs, or continuing disability reviews, a little bit more in a few slides. For SSDI, it's common that people receive overpayments for those trial work rules that we talked about before. For running afoul of those rules, and you were attempting to return to work while receiving benefits, which is again encouraged by Social Security to a certain extent, but those rules are so complex that most people want to follow those rules and they end up with an overpayment. And the other reason for an SSDI overpayment that we see commonly is, again, a continuing disability review, where Social Security says after the appeal process that you have medically improved and you're receiving benefits pending that appeal. So when you get a notice of overpayment, what should you do? There are essentially three things that you can do, and they're not exclusive, meaning that you can do all three of them at the same time. So the first, though, probably the most important, is if you believe that the overpayment notice is actually incorrect, then you can file an appeal on the notice of overpayment. That first level of appeal is called a request for reconsideration. And essentially what you're saying is that there should be no overpayment, or the amount that you're saying I was overpaid is incorrect. And you generally have 60 days from the notice of overpayment to file that appeal. And you could do that by going to ssa.gov. And on SSA's website, there's a section of the website about online appeals, and you can file an appeal directly on ssa.gov. You can also, at the same time or independently, file a request for waiver of an overpayment. And a waiver is a request that SSA essentially forgive the overpayment. And this can be requested at any time. There's no deadline for filing a request for a waiver. But to receive the waiver of the overpayment, you must show two things. One, first, you must show that you were without fault in causing the overpayment. And two, either that recovery of the overpayment would defeat the purposes of the Social Security Act, meaning that if Social Security collected the overpayment from you, you would not be able to afford the necessities of day-to-day life, like keeping a roof over your head or food on your table, or that recovery is against equity and good conscience. So again, to receive a waiver, you have to show at least two things. One, always that you're without fault in the overpayment, and two, that recovery would either defeat the purposes of the act or it would be against equity and good conscience. And you can file a waiver by using Social Security's own forms that you can find on their website. It's called a request for waiver of an overpayment form. I recommend that if you do have an overpayment and you need assistance with trying to file a waiver, calling Legal Aid of North Carolina for advice on how to do so would be helpful. Waivers can be fairly complex, and it's always helpful to hear from a legal advocate about the rules and guidance surrounding the waiver standard for Social Security. In addition to filing a waiver, you could also ask Social Security to change the amount of recovery that they're taking from your check. So if you have a overpayment from Social Security and you're still getting ongoing monthly benefits, Social Security for SSI beneficiaries can take up to 10% or $10 of your check, whichever is greater, to pay back that overpayment. And for Title II beneficiaries, so SSDI beneficiaries, as of March 27th of 2025, last week, for any new overpayments established after that date, Social Security can actually take 100% of your check away from you to recover the overpayment. Now, if you file a request for reconsideration to challenge the overpayment, or if you file a waiver request to challenge or to ask for forgiveness of the overpayment, Social Security will stop recovery of the overpayment while they're making a decision on that initial request. But if they deny that initial request, you will have further appeal rights. But unfortunately, Social Security will be able to do recovery from your check again while you're waiting to appear before an administrative law judge for a hearing to argue your case. So in those situations, if you don't want full recoupment of your SSDI check or 10% recoupment of your SSI check, you can actually ask Social Security to reduce recovery of the rate of reduce the rate of recovery of overpayment by filling out a different form that's available on their website. And you have to essentially show Social Security that if they took your full check or if they took 10% of your SSI check, essentially that you wouldn't have the ability to keep a roof over your head or food on your table again. Essentially that your your expenses exceed your income. And Social Security does have the ability, the discretion to lower recovery of the overpayment, so that you would still be able to maintain the necessities of day-to-day life. But again, you have to show that your income is lower than your the amount that you need to survive, essentially. All right, so that's another post-entitlement issue that I want you to be aware about, and that you have steps that you can take to address. The last common post-entitlement issue is a continuing disability review, and this is a mechanism used by Social Security to determine whether or not a SSDI and SSI beneficiary still qualifies for benefits on the basis of disability. And under the Social Security Act, periodically, the Commissioner of Social Security must initiate these reviews for all SSDI and SSI beneficiaries. Depending on the type of medical diagnosis or impairment you have, the review diary may be somewhere between 6 to 18 months, or it could be between 5 to 7 years for disabilities that are not expected to improve, say like an intellectual disability. Social Security will initiate a continuing disability review by sending you a notice that they're going to conduct a review and they're going to collect your medical records from your providers. And after doing a review, by having their own medical consultants look at your medical records, most people will just be continuing on benefits. Social Security say, well, you have not medically improved, or if you have improved, that improvement does not relate to your ability to work, and your benefits will continue, and everything will go on as normal. You'll continue to get your SSDI and SSI until you have your next periodic review, and then you'll go through the same process. Some people, though, Social Security, after looking at your medical records or maybe sending you out for an evaluation, will say that your condition has improved since your last favorable decision, and that you do have the ability to return to work. And Social Security, if they do that, will send you a notice of cessation saying that you have medically improved based on a review of the records. We think that you can go back to work, and we're going to be stopping your SSI and SSDI benefits because of medical improvement. That is, you no longer meet the definition of disability for Social Security purposes. And you have the right to appeal that decision. You have the right to say, that's incorrect. I have not medically improved. I still can't go back to work because of my disabling impairments. And so you would file a request for reconsideration to challenge that determination. You generally have 60 days to appeal that determination, but you have the right to receive continued benefits as well as continued Medicaid or Medicare, depending on what you were receiving, if you file that appeal within 10 days and you intentionally elect to continue to receive benefits during the pendency of your appeal. Those are called statutory benefit continuation benefits. But you have only 10 days to request such continued benefits pending your appeal. So if you are being ceased from benefits due to medical or alleged medical improvement, again, you file that request for reconsideration. And at that reconsideration level, you will actually have a hearing before an adjudicator called a disability hearing officer. The disability hearing officer works for the state agency, the Department of Health and Human Services, Disability Determination Services, and you get to have a hearing before them where you get to argue why you believe you are still medically disabled under Social Security's rules. And if you get denied at that level, you have another level of appeal where you can file a request for hearing and ask to appear before an administrative law judge at the Office of Hearing Operations, where again, you'll have the right to argue your case now in front of an administrative law judge about why you are still medically disabled under Social Security's rules, despite their determination that you're not. And again, if you file that appeal within 60 days, it's a timely appeal. But if you want to keep your benefits pending that appeal and receive those statutory benefit continuation benefits, then you need to do so within 10 days. And if you appear before an administrative law judge and you receive another unfavorable decision saying that you once again have medically improved and that improvement relates to your ability to work, you have the right to file another level of appeal to a body of judges within the agency called the Appeals Council, and that's all done on paper. If you're not successful there, then in theory, you have the right to take your case to federal court and sue Social Security in a complaint for judicial review, where essentially you're trying to tell a district court judge why Social Security made the wrong decision on your case. The important thing to know is this: if you receive a notice of cessation from Social Security because they're saying that you have medically improved, you have appeal rights, due process rights that you should exercise if you believe that you are still disabled. So I'm not going to go into detail about the standard of review for continuing disability reviews, but it's a little bit different than the standard of review for initially getting on disability benefits. So the difference is this. When you're getting on Social Security disability benefits, when you apply for SSDI or SSI, you have to prove medically that you're unable to engage in any work that exists in the national economy in significant numbers. When you're undergoing a medical review, a CDR, the standard shifts a little bit. And the question really becomes, have you medically improved from that last favorable decision? And if everything is pretty much still the same in terms of your symptoms and your limitations from those symptoms, then your benefits should continue, at least medically speaking. So this is a chart showing what the CDR evaluation process looks like. It's a 7 or 8 step process that the judge or the adjudicator is going through to determine whether or not you're still medically disabled. I think for the purposes of today, though, I don't think it's important for us to go into detail about this, but I just wanted to make you aware that this is another post-entitlement issue that you may face as a current SSI or SSDI beneficiary. So again, to summarize, there are 3 main issues in terms of how we're characterizing them today that may impact you as a beneficiary of disability benefits from either SSI or SSDI. So that could be a notice of plan action where Social Security says they're going to stop your benefits for various reasons. And what I want you to know is that you have appeal rights if you believe that determination was incorrect. It's also possible as a beneficiary that you could receive a notice of overpayment from Social Security saying you owe us money back because we paid you too much in benefits. And again, that could be due to no fault of your own. And you generally have 3 steps you can take if you receive one of those notices. You can file an appeal on the merits, a request for reconsideration. You can also file a request for waiver of recovery of the overpayment, where you're telling Social Security, hey, I am not at fault for that overpayment and I can't afford to pay you back. And 3, you can also request a reduction in the recovery rate for that overpayment. So as we discussed, for SSI beneficiaries, Social Security can take up to 10% of your check for an overpayment to recover it. And for SSDI beneficiaries, at least as of March 27th of 2025, for new overpayments established on or after that date, Social Security can take up to 100% of your benefits to recover an overpayment. And so you can take those steps that I just mentioned to either challenge the overpayment, ask for a waiver of the overpayment, or to ask for a reduction in the recovery rate of the overpayment. And then finally, another big issue that SSI and SSDI beneficiaries will face at some point when they're receiving these benefits is a continuing disability review, where Social Security is going to assess whether or not you have medically improved and still meet the definition of disability under the Social Security Act. And again, you have appeal rights if you're undergoing that process as well. So I encourage you, if you're facing any of these issues and you need legal advice or assistance, to reach out to Legal Aid of North Carolina for assistance. You can reach us at the number shown here on your screen at 1-866-219-5262, or you can file an application for assistance online for legal aid at legalaidnc.org. And Marissa, I'm going to turn it over to you and see if there's any questions from the audience, and I'll be happy to answer them. Just keep in mind, however, that I cannot give you individualized legal advice in this forum. This is a public forum. I'm not establishing an attorney-client relationship with you through the presentation today, and I also don't want you to share any confidential information in such a public forum, but I'm happy to answer general questions. But for more specific questions, I would refer you to call our helpline for assistance to see if we can help you individually with your specific legal issue if you meet our eligibility requirements.
Awesome, perfect. And so, as Brian just mentioned, if you have a question, you either need to put it in the Q&A, type it in the Q&A box on Zoom or the comment section on Facebook. You cannot unmute in this form. We do kind of have one question at the moment. I think it's just a clarifying question about how much can be taken from a disability check to pay like a back payment. I think you mentioned that
Yeah,
before.
this is a really important question, and thank you for raising it. So it depends on what kind of benefit you're receiving. So for supplemental security income, SSI benefits, Social Security can recover directly from your monthly check. They can withhold from your monthly check a certain portion of that check to repay the overpayment. And that's 10% or $10, whichever is greater. So usually it's going to be 10% of your check. So in it's a little bit complicated how they calculate the 10%, but the general rule is this. They can take essentially $96.70 from your check. That's 10% of 967, which is the maximum federal benefit rate from your SSI to recover the overpayment, unless you have a pending waiver or appeal, or unless you get the overpayment waived or reversed on appeal. Now, for SSDI benefits, or Title II benefits in general. So that would include Social Security disability insurance benefits, retirement insurance benefits, survivor benefits, auxiliary benefits. For those types of benefits, any overpayment that was incurred on or after March 27th of 2025, Social Security can actually withhold 100% your entire check to pay back that overpayment. Unless, again, you file a request for a waiver of overpayment or an appeal, which will temporarily stop the withholding until they make a determination on that appeal or waiver request. So that is a significant difference, and that's a relatively new change. So last year, in March of 2024, Social Security actually had changed their position, and for SSDI and Title II beneficiaries, they also had a 10% cap. But just a few weeks ago, Social Security announced by press release that as of March 27th of 2025, they were reversing that policy, and they're going to go back for new overpayments that occurred on or after that date, and they can take up to 100% of your check for SSDI or retirement insurance benefits. Again, that does not apply to SSI, which is a 10% cap. Now, if you're confused, I understand it's confusing. You would have to understand the differences between these two programs and what kind of benefits that you're receiving. It is very confusing, but those are the basic rules and the basic policy changes that occurred. Again, in addition to filing a waiver request for an overpayment, where you have to show that you're not at fault and you can't afford to pay it back, or challenging the merits of the overpayment itself, because Social Security may have gotten the overpayment determination incorrect, you can also ask for a change in the rate of recovery. So if Social Security is taking your whole SSDI check or retirement check because of an overpayment, you can file a request for change in recovery rate, which is essentially a form where you have to show Social Security your income and your expenses. And if you would essentially not be able to meet the necessities of day-to-day life, because of them taking your entire SSDI check from you, you can ask Social Security to reduce the rate of recovery. And in some circumstances, I've seen Social Security reduce the rate of recovery down to $10 a month because folks can't afford any more than that if they want to be able to pay their rent or their mortgage and put food on their table. But you need to take action on your own to request that. So that's really important for you to know. So I hope that addressed that question, but I admit it's complicated about when 10% recovery caps apply. Again, it's only for SSI versus when 100% recovery applies. And that would be for SSDI or retirement insurance benefits under Title II of the Act. And this is because of recent confusion caused by the policy change.
Perfect. I think that did. The next question is, if you could just go through the steps of appealing an overpayment, like what would someone need to do that process?
Okay. So I don't have a slide that goes through every step here, but I can outline it for you. So say you get a notice of overpayment from Social Security, whether that's an SSDI overpayment or a retirement insurance benefit overpayment or an SSI overpayment, the notice of overpayment is going to tell you what your appeal rights are. And it's going to say that you have 60 days in which to file a request for reconsideration. So a reconsideration request is an appeal where you say, Social Security, I think you got this wrong. And I want you to relook at this. I want you to reconsider your determination. And Social Security can then issue a notice of reconsideration saying, yeah, we got it wrong. You're right. You don't have an overpayment, or we're reducing the overpayment. Or they can say, no, you were right. The overpayment is correct. And in that notice, the reconsideration notice, it should also tell you that you have further appeal rights. And the next appeal step would be to request a hearing before an administrative law judge. The request for hearing, where you would file that request for hearing, and you can do all this through ssa.gov online appeals. And essentially, you would then get the right to appear before an administrative law judge. And you would be able to argue before the administrative law judge why Social Security's overpayment is incorrect, or why it should be a lower amount than what they say it is. And the administrative law judge can issue a favorable decision to you or an unfavorable decision. If it's unfavorable, Social Security, you can then appeal it to the appeals council within Social Security. So it's the same steps that I've mentioned for other adverse determinations. The first step is a request for reconsideration. And then after that would be a request for hearing before an administrative law judge. And then there would be a request for review of the administrative law judge's decision before the appeals council. And that same series of steps applies too for waivers. If you request a waiver of an overpayment, and Social Security denies that waiver request, we're supposed to send you a written determination saying that your request for waiver has been denied, and then you have the right to file a request for reconsideration on that. And if they deny that, you have the right to file a request for hearing. And then if you get denied before the administrative law judge, then a request for review to the appeals council. Here's something that's really important as a practice tip. Social Security loses appeals a lot. And I don't mean you're going to lose your appeal. I mean, they literally may lose your request for appeal that you filed. So it's really important to keep copies of the appeals that you file. So if you file a request for reconsideration, to keep the date stamped copy of that request, because Social Security may try to say, well, you never actually appeal that determination because they've somehow lost it in their system, which happens quite often. And you're gonna have to try to show them, no, I did file that and I have proof here. That's why I think the best way to file appeals is going to ssa.gov and filing them through their online appeal system. And after you complete your appeal, there'll be a page that you can save as say a PDF document, or you can print out. And on the top of that page should be a stamped date and time in which you file that appeal. You want to keep that. You want to try to keep every document Social Security sends to you. You're gonna, in the lifetime of being an SSDI or SSI or retirement insurance beneficiary, you're gonna collect a lot of papers. I highly recommend that you save all that paperwork. You don't know when you're going to need it again. Anything that you submit to them, you also want to save as well, specifically with a date stamped receipt on there. So either through their online appeal system, or if you file an appeal in person at a field office, which now you need an appointment to actually have an in-person appointment at the field office, to make sure you get back a copy stamp that you filed it. Or if you file it by fax, save a copy of that fax transmission sheet. But really, the preferable way to file an appeal for most appeals, where you can, is through ssa.gov's appeal system.
All right. Well, as I am not seeing any more questions, I'm going to go ahead and say thank you to all of you for joining us, with a special thank you to Brian for presenting and for answering all of those questions. If you would like to review anything that was discussed today, we have posted a recording of today's event to our Facebook page. It will be immediately available. You can access this recording with or without a Facebook account at www.facebook.com/legalaidnc. If you would like to register for any other of our Listen and Learn programs, such as tenant rights, child custody, simple divorce, you can do so on our website at Lord have mercy, www.legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a great rest of their afternoon.